Hey Alter Legal Warriors, in this video I'm going to cover the 3 biggest mistakes you need to avoid if you're served with a protection order or a restraining order in Washington State. If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Lynnwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 25 years. And I'm putting out these videos to help educate the public. So if you find these useful, please like and please subscribe. More people get to see it. More people get the help they need. Hey Lance, you just said you were a criminal attorney, but you just said in the intro, protection or restraining orders. Yeah, that's correct. Criminal lawyers and family law lawyers are the 2 types of lawyers lately here in Washington State that will do a lot of protection order / restraining order hearings. And there's 3 big mistakes that I see unrepresented people make in these hearings. Let's start though with the basics. What is a restraining order or a protection order? Now, a lot of people call it a restraining order, but the law in Washington State is called a protection order. That's under the law RCW 7.105, Revised Code of Washington 7.105, and that says, hey, if you're a person out there in the public, you can file an ex parte, that's a one-sided, with no notice, petition asking the court for relief under that law. You can ask for a DV order, an anti-harassment order, an S assault order. There's a bunch of different ones you can ask for, but basically the law says if somebody's doing a certain type of thing to you or has done a certain type of thing to you that's listed in the law, the petitioner can have the court issue a restraining or protection order against that person, saying that person, the respondent, can't do certain things. They can't be within 1,000 feet, typically, of the petitioner. They can't come to the petitioner's residence or workplace. Maybe they get thrown out of their own home if they're living with you. And so the person that's being restrained without notice is called the respondent. And so the respondent then has a chance to appear in court at a later date to say, hey, you've only heard one side. What about my side? This order should not be issued restraining my rights and freedoms. And so this video is going to cover the 3 biggest mistakes I see respondents make in these protection order cases in Washington State. So the biggest mistake that I see, number 1, is thinking that they can just go into court and tell their side of the story orally. Now that makes a lot of sense that we would think that, hey, I'm just going to testify like I see on TV. The court wants to hear from me. They want my side. I'm just going to testify. But now if you read the instructions that you are given in these things, typically they're going to talk about filing a written response. Almost universally, the court expects the respondent to file a written response so the court can have the respondent's side of the story at the time of the full in-court hearing that usually is set for 2 weeks after the original petition is granted. And people just think they can walk in and say, I'm going to swear in and talk about stuff. Just imagine, why doesn't that work? Well, number 1, there's a whole bunch of people on these protection order calendars. It's a bunch of cases. There might be a dozen or 15 cases set, and the court might have less than 2 hours to deal with all of them. One judicial officer is already going to have read the petitioner's side. They're in no position to hear your side fresh and be fully informed. It's impossible, literally impossible for a commissioner in a normal calendar to take full testimony from the respondent and give it any weight at all. What you want to see is you want to have that written out nicely so the commissioner has already read the petitioner's side and has also read the respondent's side by the time we have a court date. Usually, commissioner is going to have read all the stuff the day beforehand. They're going to have notes. They're going to have some ideas. And now they're in a position where they can really listen and look for credibility and, what someone sounds like and maybe fill in those gaps that weren't really fully flushed out in what the petitioner wrote and what the respondent wrote. So don't think it's a good idea just to go into court and say you're going to testify, because almost certainly they're not going to let you just testify. And if they do, trust me, it's typically not going to go well. It is not a fair fight. So what's the second biggest mistake I see with people that are respondents in these cases? Well, it's what they write in their response. What we don't want to write in the response is something that exposes us to criminal liability. So I see people do that way too often, where they don't realize that when they do a response, it's under oath, And it's usually responding to some pretty bad stuff that someone's written against us. So you have to think about if what you're writing in your response is admitting to any type of a crime. I've used this example before. Let's say the petitioner claims that the respondent hit him in the face, and the respondent goes, "I didn't hit him in the face, I only shoved him." Well, you may seem that shoving's not as bad as hitting, so that's why someone might write that, but that's still possibly admitting to a crime that the police or the prosecutor, if they're informed that this exists by the petitioner, they can use that to support criminal charges against you. Now, I get asked the question a lot, hey, are the police just looking through these orders and things like that? Typically, no. No one's like sifting through them. But definitely, if someone writes out something that would otherwise be a crime, a petitioner can use that and say, hey, here's their own writing and say they did something against me that was a crime. So you have to think about what you're writing. It's best to consult an attorney to help you make sure that you're not incriminating yourself, building a case against yourself on the criminal side in a civil case. Because remember, a protection order is not a criminal case. It's not the government versus the respondent. It's the petitioner versus the respondent. And the executive branch, the police, aren't involved in that at all except serving notices and enforcing an order should one be issued. So if we violate an order, then that's a crime. But simply being served with an order and having an order hearing is not a crime. It's no different than a family law case or a bankruptcy. It's a civil case. There's just consequences if we violate the order. So that's the second mistake, is writing things that expose us to criminal liability in our response. I think the third and final mistake that I see people make is they focus on the wrong things in their response. So what are my general rules for a response? Number one, we want to respond to every credible claim in some way that is written by the petitioner. If we ignore a credible claim in civil law, and this is a civil type case, oftentimes the commissioner can say, hey, if you failed to address it, then it's an admission. If you didn't deny breaking the window and you left it out of your response, well, then you must have broken the window because you denied everything else. An example where the petitioner said you broke a window. And so that's a good rule of thumb, is respond to everything. That's number one. Number two is you want to try to look like the adult in the room. You want to, look like you're the reasonable one. So even if you're not the petitioner, it's not a bad idea to put things in your response that make the petitioner look like a hypocrite, make them look like the pot calling the kettle black, putting in evidence that makes them look really mean towards you if this is a case where you being mean or abusive or harassing is somehow, at issue. So you want to make sure that you come out looking good and the petitioner doesn't look so good when you do your filing. And don't forget to include supporting evidence if you have any. Easy to read, well-labeled copies of text messages. Remember, the commissioner or judge is overwhelmed with information. Do not make it hard for them to figure out what you're trying to say in your information. They will not spend the time doing it. They just simply won't. If they can't tell which side is saying what, or if it's in another language, you got to make sure it's interpreted, right? It's the situation where you're going to get back what you put into it. So if you put little effort in, don't assume that the court is going to do the effort for you, because they're not. They're just trying to get through this case. So, and as part of what you put in there, remember, anything you file with the court needs to be served on the other side. So if you file this big, long, beautiful response with the court and you have not followed the rules for properly serving the petitioner before the hearing, because the petitioner gets a chance to reply, now the petitioner is definitely going to be granted a continuance so they can respond to what you didn't even serve them. They don't even know about it. Now that order goes on longer, and so over your head longer. And so we want to make sure not only we do the right stuff in what we file, but we follow the rules as well. So what's the long and short of it? Long and short of it is the key to a protection order case is a beautifully written response that makes it easy for the court to see your point of view, that raises credibility issues, that is filed properly ahead of time, that tells a humanly true story. And now the court can focus on who do they believe with how people present, how they appear in court, and they can eventually hopefully find, if you're the respondent, that the case presented by the petitioner, that the evidence is insufficient to support the order. I've said this before, in an order case, if you're the respondent, it's very important that we're setting up the court not to deny and say that the petitioner is unworthy, because people don't want to do that. We want the court to think the case is unworthy of issuing an order, because you don't need to go so far to have them reject the humanity of the petitioner. Just reject that the evidence is insufficient to show it's more likely than not that any of those things that can be protected occurred. And that's what we need to do. We need to avoid those mistakes. Better off you can get an attorney if you can, but if you can't, hopefully this helps. So if you found this useful, please like and please subscribe. More people get to see it. More people get the help they need. More importantly, if you're in Washington State, you have a protection order, feel free to reach out to my firm. If we get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.